Litigation on serial number 2 in the cause is WPS 4607 of 2023. Litigation I'm playing for law today. As
you don't enjoy matters on mentioning, please don't waste time in the moment. First call.
From Delhi list, fifth.
Yes,
I am seeking permission to file rejoinder in a case with this.
Just a moment. I just wanted to call you also. In just a moment, please. In that case where I have passed an order of period undergone, in your case you were arguing one case, criminal revision.
Yeah, Masham, I had argued.
You had argued it. The order is going to be uploaded today.
Yes.
But the time period which I had granted you 2 months, that is not possible. When the person is being released on period undergone, you cannot give an extended time for deposit of fine. Suppose he does not deposit, then what will happen? He will be released immediately. His bail bonds will be discharged. Then how does the system get hold of him to serve the remaining sentence in case of default? So that modification I had no option, but I have to do it. So I just informing you. And so far as the victim compensation is concerned, it will go to the legal heirs of the deceased person.
Deceased, no one is deceased in that case.
Yes, one person has died in the accident.
No, it is a case of injury.
No, you don't remember. But there is a
informant and his wife. I am
no, informant and his uncle.
No,
uncle had expired. You don't remember.
अच्छा हम दूसरे केस में कंफ्यूज करते हैं.
आप कंफ्यूजन में मत
हाँ,
आइए.
हाँ, दूसरा एक और क्रिमिनल रिवीजन था, दोनों को मर्ज हो गया. That's why.
From Delhi list.
I am seeking.
No adjournment on mention.
Adjournment नहीं रोशन को permission चाहिए कल एक matter fix उसमें rejoinder फाइल.
तो आपको permission कोर्ट मास्टर नहीं देते हैं क्या?
From Delhi list, fixed as first case, item 45, WPS 2380 of 2023.
Yes.
In this case, the petitioner has prayed for a direction for quashing the decision of the Sabha, by which the respondent number 6 has been selected. Thus, he is less qualified than the petitioner. And
She is overage also.
She is overage, but she had been working in absence of the Anganwadi Sevika. She was appointed Sahika and continuously working on that post since year 1914. And she had been given charge of Anganwadi Sevika at different periods, and his diligently worked.
But she participated in the selection process. She participated in the selection process for Anganwadi Sevika.
And she should have been given a relaxation.
I'll take care of it. WPS number 2380 of 2023. Learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was appointed as Anganwadi Sahika and has been working on the state post since 10/6/2014 and was also working in the center in absence of Anganwadi Sevika and discharging the duties of Anganwadi Sevika also. She participated in the selection process for Anganwadi Sevika, and she was not selected by alleging that she was not selected, although she was better qualified than respondent number 6, and she was also disqualified by stating that she was overage. The learned counsel submits that since the petitioner has been working as Anganwadi Sahika and was also discharging the duty of Anganwadi Sevika in absence of regularly appointed Anganwadi Sevika, therefore some age relaxation should have been given in favor of the petitioner, and the candidature of the petitioner could not have been decided against her on account of her being overage. The learned counsel for the respondents has opposed the prayer of the petitioner and has submitted that the selection process has to be conducted in terms of the rules, regulations, and guidelines. Since there is no provision for age relaxation, the petitioner would not have been granted any such benefit. After hearing the learned counsel for the parties and considering the aforesaid facts, this court finds that though no counter affidavit has been filed in the present case, but from the perusal of the amendments made in the writ petition itself, it is apparent that the petitioner claims to have been working on the post of Anganwadi Sahika since 10/6/2014 and also claims to be rendering the service in place of Anganwadi Sevika in absence of Anganwadi Sevika in the center. However, the petitioner participated in the selection process of Anganwadi Sevika held in Amsabha on 6/2/2023 but was inter alia disqualified on the account of being overage. This court is of the considered view that once the petitioner participates in the selection process, the petitioner would be governed by the rules, regulations, and norms of the selection process and cannot claim any age relaxation which is otherwise not available. Such claim cannot be made merely because the petitioner has been working as Anganwadi Sahika since 10/6/2014 and has also been discharging the duties of Anganwadi Sevika in absence of regularly appointed Anganwadi Sevika. This court finds no merits in this petition, which is accordingly dismissed.
In case there is any guideline comes in future,
Next point.
For final disclosure of item 1, WPS 2543 of 2023.
Sir, appearance.
Give your appearance, please. Give your appearance, please. Sir, written submissions.
Matter has been argued, and I have prayed for certain time to argue on a few points only, upon which this honorable court has granted me some time. Now, this matter basically relates to the rejection of the candidature of the petitioner.
Don't start afresh. You argue only that point which you have not argued on the
Yes.
last day.
Now, 3 certificates has been submitted by the this petitioner. 29/2/2020 certificate, 29 February 2020 certificate, issued by the circle officer in the central format, which is at page 48 of the memo, the paper book. That was sent by speed post.
Page 48.
Page 48.
Okay.
Which page 48, which also contains a declaration with regard to non-criminal. And only thing, a query was made by this honorable court that that is a certificate reflecting that it is other backward category. It does not reflect backward category annexure 1. That was one question which was raised. Now, after this was at the before the mains examination. After he qualified in the preliminary exam, as per the notification of the commission, he sent this certificate, and thereafter, considering this certificate, his candidature was accepted for the purpose of appearing in the mains examination. When he qualified in the mains examination, then he was called for document verification on 13 October 22, and then he has produced 2 certificates. Original of this 29/2/2020, and there is a specific averment also in the writ petition that it was told that since it is 1 year old, so give some other certificate. Then he has given one certificate dated 27/1/22, which is at page 47 of the memo. This is also in central format. This is issued by the subdivisional officer, and this also contains the declaration that he belongs to non-creamier. And on that date, he has submitted another certificate dated 24 October 2021, which is in the state format, issued by the circle officer. But without a declaration of non-creamier. The petitioner sought to rely upon the non-creamier certificate in the central format, and this was in state format, and this is also submission of this certificate is also admitted in the paragraph 32 of the counter affidavit.
And where is this certificate? Annex 24/20?
That is page 25 of the counter affidavit.
This certificate is at page 25 of counter affidavit.
Counter affidavit. Annexure B series. It mentions caste certificate to be produced by extremely backward classes under the government of Jharkhand, 24/10/21, and then the first paragraph I will read where it is mentioned annexure 1. This is to certify that Sayyid Muhammad, that is the petitioner, son of Aziz Ansari, resident of village so and so, district Bokaro of the state state Jharkhand, belongs to nomin Muslim caste, the same caste as his brother, which is recognized as backward class under extremely backward class, within bracket, that is important, annexure 1. That thing is there, within bracket, annexure 1, BC1 of Jharkhand Reservation of Vacancies and Posts for Scheduled Caste, Scheduled Tribes and Other Backward Classes Act 2001 and Professors Islam. And then it further mentions the place of residence, and number 3, that non-creamier certificate form number 11 is required to be annexed with this certificate for seeking benefit of reservation in appointment under government of Jharkhand of seeking admission in technical and technical or. So this certificate reflected that he belongs to BC1.
So you possess this form 11 also?
He did not possess the form 11. He did not submitted form 11 at that point of time. He submitted 2 other certificates in central format. The purpose of form 11 was a declaration that he does not belong to non-creamier, and the central format contains this declaration that he does not belong to non-creamier, and it reflects to the office memorandums issued by the Department of Personnel Training, Government of India on that aspect.
Once a non-creamier certificate is issued to a person, it is for all times to come.
No, it is not for all times. It is not
Therefore, the declaration of non-creamier will vary from time to time.
Yes, very. So these certificates are dated 27/1/22, 29/2/2020. It is not that it is old certificate. It is within 1 year. 27/1/22. That was the produced on 30th October 22. 27/1/22. Because on 29th February 2020, it was said that it is more than 1 year old. Then he produced this 27.
What was the date on which you could have produced the certificate as per the advertisement?
As per the advertisement, first time the candidates were.
You just refer to the provision.
Yes. After the preliminary exam results.
That was the cutoff date as per the advertisement.
Yes, and then he has sent it. He has sent 29.
Send it on the as per the advertisement when you sent your certificate. By that time you did not have this BC1 or BC2 certificate.
It was in central format. It reflected other.
That I have understood.
Yes.
But it is not reflecting whether you are belonging to BC1 or BC2.
Yes, and for that reason the candidature has not been rejected. The candidate
Whatever
rejected
it is.
that it is in central format.
That's
It
right,
does-
because it implies this only.
because the caste status is nowhere disputed, that I do not belong to backward category.
You do not.
Annexure 1. So he has all along been treated and he belongs to that. If had there been a case
That's
that,
right, we have understood.
Huh.
What else?
yes, that is one thing.
Where is that provision by which you were supposed to deposit the caste certificate?
Yes, it is the advertisement. I am just referring to page 66, starting from page 60. The relevant portion. Page 62. Page 62, column 10. That is the advertisement itself.
You just read the relevant.
Yes. आरक्षण के लाभ फर्स्ट पैराग्राफ इज रिलेवेंट प्रारंभिक चर्चा के ऑनलाइन आवेदन में अभ्यर्थी द्वारा कोटा का दावा अंकित करना अनिवार्य होगा ही इंडिकेटेड ऑनलाइन एप्लीकेशन ओनली द ऑनलाइन एप्लीकेशन वाज रिक्वायर्ड टू बी सबमिटेड विदाउट एनी अटैचमेंट thereafter the second is आरक्षण का लाभ केवल झारखंड राज्य के स्थायी निवासी he is a permanent resident of Jharkhand that has been certified and documents are there वो झारखंड सरकार द्वारा जाति प्रमाण पत्र निर्धारित विहित प्रपत्र में उपायुक्त अनुमंडल पदाधिकारी अंचल अधिकारी स्तर से निर्गत जाति प्रमाण पत्र का आधार पर ही दिया होगा the certificates which you submitted of course in central format that is issued by sub divisional officer as also circle officer both competent authorities number 2 and then the next 3 sub 10 Roman 3 the second one Roman 3 sub clause 2 it is about पिछड़ा वर्ग 2 एवं अत्यंत पिछड़ा वर्ग 1 झारखंड राज्य के पिछड़ा वर्ग 2 एवं अत्यंत पिछड़ा वर्ग 1 कोटि के उम्मीदवारों को आरक्षण का लाभ कार्मिक प्रशासनिक विभाग के 17/54 दिनांक 25/19 द्वारा निर्धारित विहित प्रपत्र 11 क्रीमी लेयर रहित में झारखंड राज्य के सक्षम पदाधिकारी द्वारा निर्गत जाति प्रमाण पत्र के आधार पर दिया होगा विहित प्रपत्र आयोग की वेबसाइट पर उपलब्ध है दिस वाज द रिक्वायरमेंट
Give me 2 more dates. After the, when was the prelims examination held?
the prelim examination was held provision article
9/1/20,
yes
right?
and
When was the result declared?
the result was declared
It was, the hard copy was supposed to be deposited on 29/2/20, as per your written submissions. This is your written submissions, right? So whatever was the document available to you on 29/2/20 is the only document which can be looked into.
only one thing I was saying that since admittedly he could not submit it in form 11 that cannot be disputed at that point of time but the thing is that the purpose of extending this benefit he is a permanent local resident he belongs to that caste all the certificates are there is a non-criminal declaration in the central format and the format 11 as well as the format submitted by him are based on the same set DOPT office memorandum dated 8
BC1, BC2 classification is not reflecting from your certificate.
the certificate which was submitted at the time of document verification 24/10/21 that reflected annexure 1
The 21 is a subsequent date, no?
24 that is a subsequent date and that is
You
the
were supposed to, as per the advertisement, you were supposed to deposit it, a hard copy was supposed to be deposited.
Yes.
There is no provision in the advertisement that you can deposit it at a later time.
yes and only one thing
And in absence of any such provision, we cannot stretch it.
and only one thing I would be just
I've understood whatever.
yes one thing the
Anything
advertisement
else you want to say?
advertisement itself says that अभिलेख सत्यापन के उपरांत 1 clause 12b page 66 अभिलेख सत्यापन के उपरांत अंतिम रूप से वैध एवं स्वीकृत अभ्यर्थी ही साक्षात्कार के लिए बात करते हैं
Estoppel.
so he was allowed to appear in the interview he produced the certificates he was to allowed in to appear in the interview
That's right.
it is not that he one thing is important we have filed that and rejoined that when after the preliminary examination the candidates including the petitioner sent their certificates as many as 183 candidature was rejected because of one or other
No,
reason.
we are not concerned with other
The
candidates.
petitioners are not, and this is one
No,
thing.
we are not concerned with that.
After being satisfied,
No,
they have
maybe.
been-
But
and at the last stage, at the time of result declaration, his candidature has been
anything
rejected.
else you want to say?
This and one thing, he has.
Whatever judgment you want to rely, you have to place it.
Yes, I
You
will
just
place it.
can't annex in the you
No, no,
place
I will
you place the
it.
judgment
Yes.
straight away.
And one representation he has made.
No, representation has
No,
not
no,
gone.
I'm making a prayer. He has asked also, give me one opportunity.
No.
Give me 1 week time, I will submit it.
Mr. Banerjee, that is not possible.
And
Please
ultimately he got a certificate in the format on 21st January
That's
23.
fair enough.
And therefore he requested that give me 1 week time, I will
You
submit
just
it.
place the
But
judgments
no
you-
opportunity has been given to
don't. Okay, you place the judgments you want to rely.
Yes. 2016 volume 4.
Yes. You are referring to which paragraph?
Yes, that is the relevant paragraphs. Paragraph 16 and 18. I will just read it. Here also, even on that, since on the last date I could not submit, here also it was a case where within the stipulated time the certificate was not submitted. Para 16, may I just read it?
Mr. Banerjee, don't take so much of time.
Yes.
Just start reading.
Para 16. Para 16, it is at page 760. In Puspa, this Puspa case was decided by Honorable Delhi High Court, which has been quoted with approval. Relevant paragraphs on Tejpal Singh have also been extracted, which read thus: the matter can be looked into from another angle also, as per the advertisement dated 11/6/99 issued by the board. Vacancies are reserved for various categories, including SC category. Thus, in order to be considered for the post reserved for SC category, the requirement is that a person should belong to SC category. If a person is SC, he is so by birth and not by acquisition of this category because of any other event happening at a later stage. A certificate issued by competent authority to this effect is only an affirmation of fact which is already in existence. The purpose of such certificate is to enable the authorities to believe in the assertion of the candidate that he belongs to SC category and act thereon, by giving the benefit to such candidate for his belonging to SC category. It is not that petitioners did not belong to SC category prior to 30th June 1998 or that acquired the status of being SC only on the date of issuance of the certificate. In view of this position, necessitating upon a certificate dated prior to 36/98 would be clearly arbitrary and it has no rational objective sought to be achieved. While taking a particular view in such matter, one has to keep in mind the objectives behind the post of SC and ST categories as per constitutional mandate prescribed under Article 15(4) and 16(4), which are enabling provisions authorizing the government to make special provisions for the persons of SC and ST categories. Article 14(4) and 16(4) therefore intend to remove social and economic inequality to make equal opportunities available in reality. Social and economic justice is a right enshrined for protection of society. The right in social and economic justice emphasized in the preamble and elongated in the fundamental rights and directive principles of the Constitution, in particular Article 14, 15, 16, 21, 38, 39 and 46 are to make the equality of life of the poor, disadvantaged and disabled society. Then para 18, para 17 refers to the Valsama Paul case reliance in Puspa. Then para 18, in our considered view, the decision rendered in Puspa is in conformity with the position of law laid down by this court, which have been referred to supra. The division bench of the High Court erred in reversing the judgment and order passed by the learned single judge without noticing the binding precedent on the question laid down by the constitution benches of this court in Indra Swami and Valsama Paul, wherein this court, after interpretation of Article 14, 15, 16 and 39A of the directive principles of state policy, held that object of providing reservation to the SCs, STs and educationally and socially backward classes of the society is to remove inequality in public employment, as candidates belonging to these categories are unable to compete with the candidates belonging to the general category as a result of facing centuries of oppression and deprivation of opportunity. The constitutional concept of reservation emphasized in the preamble of the Constitution as well as Article 14, 15, 16 and 39A of the directive principles of state policy is to be achieved. The concept of giving equal opportunity to all sections of the society. The division bench thus erred in reversing the judgment and order passed by the hence the so it has failed to follow the binding precedents of the judgment of this court in Indra Swami and Valsama. This is one. One judgment of all. Honorable Court. This is 2013 one JCR. I have given the copy also. Tausif Raja, WPC 4752 of 2012.
Which is the page number?
Page 47. It starts from page 47. And I will be.
You have not even numbered your written submissions. Page numbering is not there.
Sorry,
So where do I do?
that is a mistake on the part.
WPC 4572.
Yes.
Para number?
Para number 11 and 12. I will just read it. Para 11, thus it is apparent that the caste certificate issued by the government of Jharkhand to the petitioner includes all the necessary details, as the petitioner is contending in this case. All the necessary details which were asked by the respondent authorities for admission of the students in the Indian Institute of Technology if they are otherwise meritorious. It is further submitted in the facts of the case the respondent authorities are insisting for certificate in English language, and that too in the format prescribed by the IIT. In this context, it has to be kept in mind that a student has no control over a sovereign body like state of Jharkhand, and the state of Jharkhand issues caste certificate in their own preferred language, as stated herein above, and therefore it is very much apparent that due to no fault of the petitioner, he has been denied admission. Then para 12, it further appears from the facts of the case that respondents have taken a view that the certificate should have been issued by the government of Jharkhand in the format as prescribed by the respondent authorities, and that too in English language, and then only the petitioner will be admitted. This is not permissible in the law, and the certificate containing all the details required by the respondent authorities, even if issued in Hindi language, should have been given due weightage. It appears that the Summon to other founders agents in this country, institution is state within meaning so and so. Should have prescribed their forms in Hindi also. Any certificate issued in Hindi by any state cannot be ignored or brushed aside by the state which is also within the meaning of Article 12 Constitution of India. So it says that all the necessary details are there in the certificate, as in the case of the petitioner, since he was found to be eligible and qualified. Therefore, the petitioner is relying upon this judgment. It is also on the issue of format. Then one judgment of this Honorable Court which has been appealed up to the Honorable Apex Court. This also given the compilation. Anil Tati, WPS 1630 along with W1412 of 2017. Decided on 13 October 2017. Paragraph 6 of that judgment.
Para 6.
Para 6. I'm just reading it. Be that as it may, having gone through the rival submission of the parties, this court is of the considered view that the case of petitioner needs consideration. The ground for rejection of the candidature of the petitioners is that they have not submitted their caste certificates in proper format. It is not a case that caste certificates of the petitioners have not been issued by the competent authority, or the petitioners do not belong to extremely backward class category. The rejection of the candidature of the petitioner who belongs to EBC category on ground of non-submission of the certificates in proper format and not allowing them to submit their certificates after the cut-off dates amount to violation of Article 14, 15, 16 and 39A of the Constitution. The ground of rejection is not only erroneous but also suffers from error in law, as it has failed to follow the binding precedent of the judgments passed in case of Indra Sani versus Union of India, in case of Alsama Paul, so and so. That issue failed for consideration before the Honorable Apex Court, the case which the petitioner Ram Kumar Gejoria, and the question of law arose for consideration whether a candidate who appears in the examination under OBC category and submits a certificate after the last date mentioned in the advertisement is eligible for selection to the post under OBC category. Answering in affirmative, the Honorable Court was of the view. Then it has been quoted. I am not skipping those. It has the Honorable Supreme Court judgment which the petitioner also placed reliance upon, that has been quoted there. Ram Kumar Gejoria. Para 6 is relevant for purpose of this. And para 7 just narrates the things. It has been held by the Honorable Apex Court that object of providing reservation to SCs, STs, paragraph 7 after the Honorable Supreme Court's judgment is quoted, para 7, the last word one. It has been held by the Honorable Apex Court that object of providing reservation to SCs, STs and educational and socially backward classes of the society is to remove inequality in public employment, as candidates belonging to these categories are unable to compete with the candidates belonging to general category, and as a result of facing centuries of oppression and deprivation of opportunities, the object is to achieve the concept of giving equal opportunity to all sections of the society, and thus not considering the cases of the petitioners is highly arbitrary and also against the settled principle of law, violation of Article 40 and 6. This judgment has been upheld, and given the judgment of the Honorable Apex Court, the SLP filed by the Commission, that has been dismissed. It was upheld by the division bench and then the SLP has been dismissed.
Why have you stopped, Mr. Banerjee? You continued.
Yes, that is the.
Don't pause.
And
I'm
the,
absolutely receptive to whatever you are saying.
and the last.
Don't pause in between. You
And
just
the last judgment which the petitioner is relying upon, that is division bench of the Honorable Delhi High Court, that have given the copy 2022 SCC online, Delhi 2621. That refers to paragraph 40, the document on record. The documents on record establish that the appellant belong to the OBC non-creamier category. I am reading para 40. The documents on record establish that the appellant belongs to the OBC non-creamier category and she was OBC non-creamier category candidate on the cut-off date for submission of the documents, that is on 31/12/2021. She was in the OBC category at the time of issuance of the advertisement, and today also she belongs to OBC non-creamier category. This court, keeping in view the totality of the circumstances of this case, is of the opinion that the respondents have taken a hyper-technical approach by denying the right of appointment to the petitioner, especially when undisputedly right from 2015 till date she is a member of OBC non-creamier category. And then para 42, there is reliance upon the judgment of Ms. Puspa, which has been quoted with approval by the Honorable Supreme Court, page 40, para 42. And then I am skipping the quoted portions. Paragraph 45 is the conclusion after. para 45, that is, in the considered opinion of this court, the appellant who was a member of OBC and non-criminal category did submit a certificate to that effect, and the fact is that she was a member of OBC NCL category while she appeared in the examination. As in wrote also, she is a member of OBC NCL category. The same has not been disputed by the respondent. Thus, the question of depriving her of the right to be considered for appointment under OBC category does not arise.
That's all.
Yes.
Please have a seat. And don't disturb the respondent while they are arguing. Right? Yes.
But can we turn to the terms of the admitted? What
Yes.
was the requirement made in the admitted reports? Annexure 4, page 60.
Yes.
Clause, your lordship. 10 at page 62.
Clause 2A.
Clause 10. Page
Clause
60.
10.
Your lordship. Page 62.
10. Yes.
My lord, what was the requirement, your lordship? He is, your lordship, EBC1, your lordship. The EBC1, regarding EBC1 is mentioned at clause 10, subclause 3, 2, at bottom, your lordship.
Incidentally, I wanted to know from you, EBC 1 and BC 1 are one and the same thing?
No, my lord, different. My lord, the criteria is different, your
No
lordship.
criteria, I just wanted to know,
Your lordship.
not for this case, for some other purpose.
My lord.
That BC 1 and you have BC 1 and BC 2 category.
BC2.
What is EBC then?
My lord, that is BC1 is EBC1.
That's right.
My lord.
This is what.
My lord.
There was some confusion
My
in
lord,
correcting
BC1
an order.
and EBC1 is same.
There was some confusion in correcting an order
My lord.
that those terms were interchangeably used in the writ and the counter affidavit. So I was slightly
My lord,
wanted to have this.
The EBC1 and BC1 is same.
Okay.
Same.
Okay.
मतलब 10-3-2 मैं read your thoughts.
Yes.
झारखंड राज्य के पिछड़ा वर्ग 2 एवं मतदान पिछड़ा वर्ग 1 के कुछ उम्मीदवारों का आरक्षण का लाभ कार्मिक प्रशासनिक सुधार का राजभाषा विभाग झारखंड के पत्रांक 1752 डेटेड 25/2/2019 द्वारा निर्धारित विहित प्रपत्र 11 क्रीमी लेयर रहित में झारखंड राज्य के सक्षम पदाधिकारी द्वारा निर्गत जाति प्रमाण पत्र के आधार पर देय होगा। विहित प्रपत्र आयोग के वेबसाइट पर उपलब्ध है। My lord, the criteria has been mentioned that only the benefit of reservation will be extended to those candidates who will submit the caste certificate in pro forma for EBC1 in for pro forma 11, your lordship. Then your lordship kindly turn to clause 12 at page 66. That is relevant, your lordship. And my lord, Gijroya case has already been, your lordship, considered by this honorable court and recently by the honorable Supreme Court and has held that it is not good law. I have given your lordship. 12, your lordship. आवेदन पत्र भरने हेतु आवश्यक शर्त एवं निर्देश। ऑनलाइन आवेदन के साथ किसी तरह का प्रमाण पत्र संलग्न नहीं करना है, किंतु ऑनलाइन आवेदन में प्रमाण पत्रों से संबंधित कॉलम में सभी सूचनाएं सही अंकित करना है। प्रारंभिक परीक्षा में सफल उम्मीदवारों के द्वारा कंडिका 12 क्यू में निहित निर्देश के अनुसार ऑनलाइन आवेदन में मुद्रित 100 हस्ताक्षरित प्रति के साथ ऑनलाइन आवेदन में की गई प्रविष्टि के अनुरूप, दैट इज इम्पोर्टेंट योर लॉर्डशिप, सभी वांछित प्रमाण पत्रों की स्पष्ट एवं पठनीय 100 अभिप्रमाणित छाया प्रति हार्ड कॉपी मुख्य परीक्षा के पूर्व ऑनलाइन आवेदन की प्रति के साथ जमा किया जाना अनिवार्य होगा, जिसकी सूचना प्रारंभिक परीक्षा के परिणाम प्रकाशन के उपरांत प्रेस विकृत माध्यम से अभ्यर्थियों को दी जाएगी। हार्ड कॉपी जमा नहीं करने वाले उम्मीदवारों की उम्मीदवारी रद्द की जाएगी तथा उम्मीदवार इसके लिए स्वयं जिम्मेवार होगा। बी, साक्षात्कार समय अभिलेख सत्यापन के द्वारा ऑनलाइन आवेदन में की गई प्रविष्टि एवं तदनुसार मुख्य परीक्षा हेतु समर्पित प्रमाण पत्र। माय लॉर्ड, आई विल स्टॉप फॉर ए मोमेंट योर लॉर्डशिप। The clear stipulation has been made, your lordship, that only those candidate certificate will be considered which have been mentioned in the application form, your lordship. No other documents can be considered, your lordship. That is the stipulation, your lordship. और मूल प्रति प्रस्तुत करना अनिवार्य होगा, अन्यथा औपबंधिक रूप से स्वीकृत अभियंता रद्द कर दी जाएगी। तो इसके लिए आवेदक स्वयं जिम्मेवार होंगे। अभिलेख सत्यापन के उपरांत अंतिम रूप से वैध एवं स्वीकृत अभियंताओं के साक्षात्कार के लिए पात्र होंगे। नेक्स्ट डी,
The document at the time of online application, you have to mention about your credentials,
क्रेडेंशियल,
and immediately after declaration of result of preliminary and at the time of giving mains examination,
exactly correct.
the hard copy of the same document is to be produced
My God, my God.
and
Submitted,
then
submitted.
submitted.
And that was to be produced at the time of verification of the testimony. That is the your lordship condition. D, this is important. अभ्यर्थी ऑनलाइन एप्लीकेशन भली भांति विज्ञापन में निहित सभी प्रावधानों को अनुसार ही भरे। एक बार ऑनलाइन एप्लीकेशन में की गई प्रविष्टि के बाद उसमें किसी भी तरह का परिवर्तन का अनुरोध स्वीकार नहीं होगा। That is the condition, your lordship. My lord, what he did, your lordship, he was declared successful. He was granted benefit of reservation in PT examination. He was declared successful, and he was directed to submit the, that is Annexure 6 of the writ application. Your lordship, kindly see at page 71. पेज 71। संयुक्त सहायक अभियंता सैनिक इतना प्रावीण्य पेशा सफल घोषित अभ्यर्थी के प्रकाशित विज्ञापन संबंधी के निर्देश के खंडिका 12 के अनुसार ऑनलाइन आवेदन में मुद्रित 100 हस्ताक्षरित प्रति के साथ ऑनलाइन आवेदन में की गई प्रविष्टि के अनुरूप, मतलब जो पीटी में हम किए थे, के अनुरूप सभी वांछित निम्न प्रमाण पत्रों का स्पष्ट एवं पठनीय स्वाभिमानित छाया प्रति हार्ड कॉपी निर्धारित अवधि दिनांक इतना से इतना तक 15/9/2020 तक आयोग के कारण निबंधित डाक स्पीड के माध्यम से अनिवार्य रूप से भेजना सुनिश्चित करेंगे। My lord, we are concerned with your lordship the caste certificate, your lordship, that is mentioning, your lordship, clause 4 जाति प्रमाण पत्र विहित प्रपत्र में।
That's it.
My
I've
lord.
seen it.
Then 5, your lordship, EW. Then your lordship, last, ऑनलाइन आवेदन की प्रति सहित अभिलेख प्राप्ति की अंतिम तिथि के पश्चात प्राप्त आवेदन अभिलेख स्वीकार नहीं किए जाएंगे। My lord, what he has mentioned in the online application form and submitted along with the application form, that will be only considered. My lord, then kindly turn to his statement, your lordship, para 20 of the writ application, page 20.
Yes.
Para 20. That thereafter the petitioner regarding mains examination sent the JPS by institute the hard copies of the required certificate including caste certificate number JSCOB. My lord, OB means, your lordship, other backward class, means for the central government. /2020/08146 dated 29/2/2020 issued from the office of Circle Officer Bomia. My lord, he has submitted the caste certificate of central format, and the said caste certificate is at annexure annexure, your lordship, page 48.
Yes.
Page. This is the caste certificate mean fit to OBC category. My lord, thereafter, your lordship, he was allowed to appear in the examination, your lordship, and he was also declared successful in the mains examination. At the time of verification of the documents, he produced another caste certificate, your lordship. He also produced the OBC caste certificate. That was not valid in terms of the advertisement, and another caste certificate issued after the last date, your lordship, that I have indicated, your lordship, in my supplementary counter affidavit, your lordship, filed on, I have enclosed, your lordship, the verification documents. Supplementary counter affidavit on 23/2/2024.
23/3.
23/2/2024. Supplementary counter affidavit on behalf of the civil of 4 entities.
That's
My lord, kindly see, this was the document produced by him, your lordship. यहाँ पर category PS details, category BC1, claim, derivative no, certificate, JBCJ इतना dated 24/10/2021. This document was produced, your lordship, which was not mentioned in the online application form, and the same was issued after the submission of the online application form, your lordship. My lord, the material date would be 11/11/2019. That was the last date of the submission of the online application form for the PT examination. And he has also, your lordship, may I allow to read, your lordship? No form 11, not annexed, issue date after hard copy submission last date. Earlier caste certificate in central format dated 29/2/2020 submitted at the time of hard copy submission.
That's
My lord, thereafter, your lordship, his candidature was considered, and since he has taken benefit of reservation in the PT examination, the benefit of reservation was not extended to him, your lordship. That has been indicated in, your lordship, the mark sheet of the petitioner, which is at annexure 9, page 74.
this.
My
That
lord,
we have seen.
this is, your lordship, the remark column. Candidate got benefit of BC1 category in PT and mains result, but caste certificate submitted in central format, hence candidature rejected. My lord, that was the reason that he has submitted the OBC caste certificate, and as such it
That's
was
right.
rejected.
Got it.
Now the question would be, your lordship, whether any caste certificate which was not mentioned in the online application form issued after the last date can be accepted for extending the benefit of reservation or not. That has already been decided by this honorable court in several judgments, your lordship. My lord, I will place, your lordship, the judgment.
You see, the main issue would be, irrespective of the date of submitting caste certificate, the main point would be whether the caste certificate which does not disclose
My lord,
whether he belongs to BC1 category or BC2 category could have been used by him, because the format which you are relying upon specifically indicates the category because
Right.
it follows the reservation,
your lordship.
right? So his caste certificate never disclosed that category.
My lord.
And therefore whether, irrespective of the fact when he produces the caste certificate,
Right.
but when till the last he did not produce a caste certificate indicating as to under which category he is belonging,
Right.
whether BC1 or BC2.
BC. My lord, that has already been decided by this honorable court that OBC certificate is not valid for extending the benefit of reservation, and any caste certificate which is submitted later on cannot be considered. Kindly have a look. I am placing that, your lordship. Kindly look to annexure 7 of my written notes of argument, your lordship, page 114. There are other judgments also, your lordship. Recent judgment I have also included, your lordship. Annexure, my lord, there is some mistake in page numbering, your lordship, in my brief and your lordship's brief, but it is annexure Roman 7.
Yes.
May I read, your lordship?
Rishi Kumar.
Rishi Kumar, LP, your lordship,
Yes.
decided by the Honorable Division Bench. Para 2. May I read? Learned counsel appearing for the appellant submitted that this appellant original had appeared in the examination.
That's right.
Appear in the examination for the post of civil judge within bracket junior division conducted by the Jharkhand Public Service Commission. This appellant had applied for the post with the certificate of other backward class, that is in the central format. The certificate is annexed at annexure 3 to the memo of this letter patent appeal. This appellant was allowed to appear in the examination as BC2 category. Thereafter, he cleared preliminary and mains exams. He appeared in the interview, and during the process, he had also presented the original of annexure 3 as well as a certificate of BC2 category issued by the Block Development Officer Rahul Kundu Subdivision. Next, your lordship. Ranchi, which is at Annexure 12 to the memo of this latest pattern. Despite this, it has been considered by the respondent that this appellant is a general category candidate and the benefit of reserved seat for BC2, which are 7 in number, has not been extended to this appellant, and hence writ application was preferred by this appellant, which was dismissed by the learned single judge without appreciating the fact that at the time of interview, original of Annexure 3 as well as original of Annexure 12, that was after last date, your lordship, not mentioned in the certificate were for the certificate at Annexure 12 issued by the block development of Dano Pundu, Ranchi have 2 dates such and such, and another this aspect of matter has not been properly appreciated by the learned single judge, and hence the judgment and order delivered by the learned single judge deserve to be quashed and set aside. Next, learned counsel appearing for the respondent JPS submitted that the requirement of the certificate as stated in the advertisement.
That is your submission, you just come to the
my lord.
findings.
Para 4.
Para
Having heard learned counsel for both the side and looking to the facts and circumstances of the case, we see no reason to entertain this latest patent appeal mainly for the following facts and reasons. Public advertisement bearing number such and such was published by the Jharkhand Public Service Commission for the post of civil junior. There were reservations for several category candidates, including BC2 category. 7 seats were reserved for BC2 category. Looking to the public advice issued by the Jharkhand Public, it appears that there were specific format in certificate are to be given by the candidate. If they are claiming any benefit for the reserved quota seat, the format were also made available on the website as stated in the public advice. It appears this appellant has not given caste certificate BC2 in format which is prescribed by the Jharkhand Public Service Commission. The appellant has placed heavy reliance upon Annexure 3, but the same is not helpful to this appellant mainly for the reason that Annexure 3 certificate is for the other backward category class. This certificate is content certificate of BC1 and BC2 category. By virtue of Annexure 3, this candidate may also belong to BC1 category. Thus, the said certificate is never prescribed by the Jharkhand Public Service Commission and it is not helpful for this appellant. And thereafter, your lordship, the finding has been given in para Roman 4.
that we have seen.
My lord, thereafter, your lordship kindly turn to. My lord, I will also place the several judgment I have enclosed, your lordship, but your lordship.
You can just distinguish Ram Kumar.
Ram Kumar ji jo hai,
That should be sufficient.
that
We
I
just
have
distinguish that which judgment is the best judgment.
My lord. My lord, kindly see Annexure Roman 15, your lordship, page 191. Whether any caste certificate produced at later stage before the commission at the time of the document verification can be considered or not.
Page 9.
Page 191. Roman 15 Annexure.
Roman 15.
My lord.
This is the writ petition decision.
Read petition, your lordship.
Yes.
The petitioner has approached this question with a prayer for passing the note given in the final remark, a statement issued in favor of the bill in which it has been made a final remark that candidature of has been rejected in view of clause 7 on of the citing reason that the C has submitted the residential certificate instead of caste certificate. Next, petitioner has further prayed for direction upon the respondent Jharkhand Public Service Commission to consider the caste certificate of petition and issue offer as C has obtained 574 marks, which is more than the last selected candidate under ST category in combined civil services examination 2021. The respondent JPSC has issued advertisement number such and such. My lord, this is important and as such I am reading your lordship. Being eligible, next page, had applied for appearing in the recruitment process under ST category. Thereafter, the petitioner appeared in the preliminary test in which he has declared success and become entitled to appear in the mains exam. Thereafter, the respondent JPS invited application for combined civil service exam from the candidate who had passed the preliminary exam pursuant to which the petitioner filled out the form for mains exam under ST category. Subsequently, the petitioner appeared in the mains examination in which she was declared successful. Thereafter, the respondent JPS has uploaded interview later for combined civil service examination 2020 and by way of said data it has been informed to the petitioner that she has been shortlisted for documents verification interview and directed to appear to interview for document verification which was scheduled on 11/5/2022 and 12/5/2022. As per the instruction of respondent JPS, the petitioner appeared on the first time she came to know that she has uploaded residential certificate instead of caste certificate. On that information, the petitioner immediately on the very day submitted the valid caste certificate issued by the circle officer such and such in prescribed format issued on 18/10/2019, and the respondent authority has kept the same on record. Same, your lordship, he
So you
argued.
just just show us the finding.
My lord, finding is this, your lordship? Finding is this, your lordship?
Where is the finding?
My lord, finding is, my lord, starts, your
Para
lordship,
24.
para 20. 20 onwards starts, your lordship.
You can come to para 24.
My lord, 24 is also important, your lordship. My lord, I am deeply obliged, your lordship. From the facts stated, it is crystal clear that petitioner has committed mistake in uploading her caste certificate during filling of the online application form for the mains exam, and as a benefit of reservation had not been extended to the period her candidature has been rightly been rejected, and there is no illegality not extending the benefit of reservation and rejecting the candidature of the petitioner respondent JPSC. Thereafter, your lordship, para 26, what he has argued, your lordship, about Ram Kumar Vijroya.
Yes. The state contention.
Mr. Such and such learned senior counsel appearing for the petition course of the argument, they tried to impress upon this court in view of Ram Kumar Vijroya versus such and such, it can comfortably be inferred that the case should be submitted at any point of time. The said contention of Mr. Sinha is not worthy to of the stated or by this court in view of the specific terms and conditions of the advertisement as well as instruction of the Jharkhand Public Service Commission for submission of online application form and uploading the document merely because Jharkhand Public allowed the petitioner to appear in the record as scheduled. Type candidate no right to her to claim for the petitioner after being declared as was right to appear for verification testimony. There only it was found in place of caste she has uploaded the results on her online application, and as such it becomes a specific ground for not extending the benefit of reservation to the petitioner. Thereafter, the petitioner produced the caste which was not considered by the respondent in view of the specific terms and conditions of the examination instead in the advertisement, and as such a candidate was rejected. Law is well set that terms and conditions of the cannot be altered as per the suitability of the candidate if prayer of the petitioner is considered same will amount to relaxing the terms and conditions to which other particular candidate it is allowed in one case, why not the same be allowed for all other candidates? Thereafter, your lordship, para 28. The Honorable Apex Court in the case of the state of Tamil Nadu versus such and such reported in such and
In
such.
para 27, they have the stipulation reserved category candidate will have to upload the caste certificate along with online application form is not
For
there.
the mains examination.
Here also on online application form it was
in
to
this
be. Identical clause.
Identical clause, your lordship. Thereafter, your lordship,
That's
para
right.
28.
I have got it.
Huh.
Let them respond.
My lord, thereafter, your lordship, para 33. Ram Kumar Vijroya case. The heavy reliance of learned senior counsel for the petition in case of Ram Kumar Vijroya is no help to him on the ground that in that case it has been held that where there is no specific stipulation regarding submission of caste certificate at a particular date, then the candidature of candidate concerned could have been considered. But here in the instant there is a specific stipulation regarding submission of online application form, and thereafter the same shall not be considered if at any point of time difference is found in the online uploaded caste certificate and original caste certificate produced by the candidate. Here, instead of caste, the petitioner uploaded her residential and it was only at the time of when the said certificate has been produced, which was rightly not accepted and considered accepted at the candidates of petitioner were rejected by the respondent JPSC. My lord, thereafter the lead application was dismissed. My lord, now come to Ram Kumar Vijroya case. Ram Kumar Vijroya case, your lordship. Ram Kumar Vijroya case has considered by the Honorable Supreme Court last year, lordship, and it has been held that it is we will not follow that because while passing the order in Ram Kumar Vijroya case, the Honorable Supreme Court has not considered the full bench judgment of the Honorable Supreme Court in Ram Kumar Sharma case. Your lord, that I will produce, your lordship. Same matter, your lordship. Now not producing the caste certificate, EWS certificate up to the last date of submission of the online.
There is a judgment of the
My
Honorable
lord,
Supreme.
my lord, I have annexed your lordship. My
Where
lord,
is it?
first of your lordship, kindly have a look to Ram Kumar Vijroya case. Ram Kumar Vijroya case has also been considered by the several division bench. In this case, I have
Yes.
annexed your lordship, annexed 10 onwards, your lordship. My lord, kindly see page para 8 at page number 758.
Yes. Para 8.
Mr. Such and such learned counsel appearing on behalf of the Conduct Division of the High Court are not giving the opportunity to submit the OBC certificate after the cut-off date of the appeal. The requirement of submitting of the OBC certificate before the cut-off date of the application was introduced by the respondent DSSSB only while declaring the result on 15/12/2018.
That's right.
My lord, this is the point. Then your lordship, my lord,
Where is the judgment of the Supreme Court?
my lord, kindly see annexure 1, Roman 1.
Yes. Yes.
My lord, the first paragraph is important, your lordship. That is, your lordship, decided on 9/10/2023. These writ applications raise questions involving the interpretation of the office memorandum dated such and such, prescribing the limit for the economically weaker section EWS category. Additionally, they also involve the interpretation of the civil service exam thereof. The petitioners, for diverse reasons, were denied the benefit of EWS category by the Union Public Service Commission for the civil service examination of year 2022, while the UPSC justified in denying them the benefit of reservation under the EWS category is the main question involved. The three writ applications involve different sets of defects. The factual parts are dealt with separately. The legal submissions broadly overlap here. However, they need to be separately discussed. The same has been done at the appropriate place. The petitioner, Mr. Such and such, by the
So where is the observation of
my lord, observation is your lordship. My lord, kindly see para 5.3. Page number 3, your lordship.
crucial
The
date?
crucial date for submitting income and asset certificate of the candidate may be treated as the closing date for receipt of application for the post, except in cases where crucial date is fixed otherwise. Next, your lordship. Then your lordship kindly turn to para 7. Para. A careful perusal of the rules should disclose that under Rule 28, candidates seeking reservation under EWS for the purpose of CSC 2000 must ensure that they are entitled to such as per the limit prescribed in the rules. The limit prescribed for EWS under Rule 27(3) is that the candidate should meet the criteria issued by the central government and should be in possession of the required income and asset certificate based on the income for financial year 2020-2021. Secondly, the candidate should also be in possession of all the requisite certificate in prescribed format by the closing date of the application for civil services examination 2022. It can be seen from the above mentioned clause that the benefit of this can be availed on possession of income and asset certificate issued by the complainant under the clause itna of the crucial date for submitting the IO may be treated as the closing date for receipt of the application for the post, except in cases where crucial date is fixed otherwise. Next, your lordship. 9. The applicable date for position in this case is 22/2/2022. This is because after the promulgation of the third responding Union Public Service Commission issued the examination notice on 2/2/2022 and last date for submission of the application was 22/2/2022.
That's
This para 12. What is clear from the above is before the closing date of the candidate has to be in possession of the requisite certificate for such and such, and before the main exam the candidate is expected to upload the certificate. Same clause here, your lordship. Thereafter, your lordship. 14. I am only reading the relevant
no, you
paragraph.
just read the observation of the Supreme Court in
My lord,
connection with
my lord, then your lordship, I will take to your lordship. Para 33.
this paragraph. You just come to the findings. Please
Findings,
don't
your
read the
lordship.
entire
I am
judgment.
coming, your lordship. My lord, kindly see para 34 in second page, your lordship.
Para 34.
The learned counsel distinguish the case of Charles case such and such, such and such, and such and such by stating that in those cases.
No, this is all submissions.
My lord, my lord.
Where is the finding?
My lord, findings, your lordship.
You said that some observation
My
has
lord,
been
my
made.
lord,
Where is that
I
observation?
am coming
Go to see.
para 54. Para 54.
Yes.
My lord.
Yes, please.
The strong reliance placed on Ram Kumar Gijuraya case also does not impress us. Not only was there no rule like we have in the present case, it was only the while declaring the result, the requirement of submitting the OBC certificate before the cut-off date was introduced by the selecting authority.
That's right.
There, moreover, unlike the present, there was no contention or issue raised in that case that eligibility ensured or catalyzed only on the issuance of the certificate and on the position of the before the prescribed cut-off date.
That's right.
Next, the judgment in Ram Kumar Gajuraya is also directly in conflict with the judgment of three honorable judges in the Ashok Kumar Sharma and others versus Chandrasekhar and others, where in para 6 it has been held under your lordship.
That's right.
There, your lordship, and thereafter, your lordship, para 56 is also important. The matter was also referred before the larger bench. The larger bench did not answer the issue. May I read?
Yes,
Apart
yes.
from all this correctness of Ram Kumar Gijuraya case was referred to a three-judge bench in the case of Karan Singh Yadav. A perusal of para 6 of the referral order clearly shows that the bench was echoing the ratio of the three-judge bench in the Ashok Kumar Sharma case, though there is no express reference to the said case. However, when the matter come up before the three-judge bench, the reference was not answered, and even after noticing that the Ram Kumar Gijuraya has covered the case of Karan Singh Yadav, the court, however, denied the relief to Karan Singh Yadav. The petitioner was holding that since the appellant was never appointed to the post to that length of time, it was not possible to grant any relief to the appellant. Ram Kumar is clearly denied. Be that as may, para 57. Be that as may, we are bound by the judgment of the three-judge bench in the Ashok Kumar Sharma, and we follow the said judgment and dictate the principle laid down there on. It also interesting to note that even in Deepak Sharma's judgment, strongly light upon the responsibility, the principle in Ashok Kumar Sharma case has been dictated. However, because of the court count in forward, there this is your lordship. Thereafter, para 58, negligence of the respondent petitioner, and thereafter the writ application by this. And thereafter, your lordship, several judgment I have enclosed, your lordship, that is Annex 13, LPA order in Sweta Kumari case, your lordship, that any caste certificate which is not in format submitted at the time of the submission of the application for cannot be considered for extending the benefit of reservation, and other caste certificate produced at the time of verification cannot be considered. That is Annex 13, 14, your lordship.
13 and 14 of
14
this
also,
bunch.
your lordship.
Give the case number.
My lord, that I have annexed, your lordship.
No, give the case number.
LPA number 91 of 2020,
LPA number
91 of 2020.
91 of 2020.
Thereafter, your lordship, order dated 27/10/2021. Order, sorry.
In LPA?
27/10/2021.
In LPA?
LPA, your lordship. LPA number 91 of
21/10/21. Yes, that's all.
Then your lordship, LPA number 610
On the
of
same point,
2000.
why do you need to multiply?
My lord,
This
that is
LPA should be
dictated.
sufficient?
And my lord, in Rohan Thakur case, your lordship, the honorable this division bench earlier has distinguished, your lordship, that Ram Kumar, now Ram Kumar Gijuraya is not
That's
a good case, your lordship, in view of the Divya judgment.
That's all?
My lord,
Yes.
that's all.
You have to say anything in response?
The factual aspect of the matters which are cited is different in as much as in the present case, the document which was sent at the time of main examination, that was original of that was produced, and it has never been considered that the details which were sought in the format, all those particulars and details are there in this format, which has been considered in the case of Tausif Raja by this honorable court. And so far as Ram Kumar Gijuraya is concerned, that has been quoted with approval by a three-judge bench judgment in Karni Singh Yadav recently, SLP Civil 14948 of 2016. A two-judge bench referred it to a larger bench, a three-judge bench, and Karni Singh Yadav has
So that has not decided the issue.
That
It
has
is-
a
but it been quoted with approval.
That's right.
Quoted with approval. So it cannot be said it would be not proper to say that it is not a correct.
That's all.
Yes.
obliging.
I will just record your submissions. You please have patience for some time. In furtherance of the arguments advanced by the petitioner on earlier occasions, the learned counsel has submitted that the advertisement in the present case was issued on 18/7/2019 and preliminary test was held on 19/1/2020. The petitioner had at the time of filling up the form, the required certificates were not to be uploaded, and the petitioner was subsequently issued the certificate by the circle officer on 29/2/2020 in the central format, but all the required information in connection with the petitioner to claim reservation was available in the said certificate. He submits that in the said certificate it was also certified that the petitioner did not belong to creamy layer. He has further submitted that the document verification was done on 13/10/2022 and on this date he produced the original certificate dated 29/2/2022 and also one more certificate issued on 27/1/2022 as contained in page 47 of the writ petition, which was also in the central format issued by the subdivisional officer. This certificate also indicated that the petitioner does not belongs to non-creamy layer. This certificate was issued by the subdivisional officer, correct?
Yes.
This certificate was issued by the subdivisional officer. The learned counsel has submitted that the format of the certificate is irrelevant once all the relevant information are furnished in the certificate which is issued by the respondent themselves. The learned counsel has further submitted that the petitioner was subsequently issued the caste certificate mentioning that the petitioner belongs to BC1 category, which was dated
24/10/21.
24/10/2021, and such caste certificate was also produced by the petitioner at the time of document verification. He submits that the caste certificate dated 24/10/2021 read with non-creamier declaration and the declaration of the caste of the petitioner as issued under the central format was complete in all respect, and therefore the petitioner could not have been denied the benefit of reservation. The Learned Counsel has referred to the Annexion 9, by which the candidature of the petitioner was rejected by indicating as follows, inverted comma, candidate got benefit of BC1 category in PT and mains result, but caste certificate submitted in central format, hence candidature rejected. The Learned Counsel submits that the sole reason for rejection of the candidature of the petitioner was that he had submitted the caste certificate in the central format. The Learned Counsel submits that the Learned Counsel has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2016 bracket close 4 SCC 754 para 16 and 18. He has also referred to writ petition decided by this court in WPC number 4572 of 2012 decided on 6/10/2012 para 11 and 12 semicolon WPS number 1630 of 2017 decided on 21/8/2017 para 6 and 7, which was confirmed in LPA number 610 of 2017 decided on 12/10/2018 and has been upheld up till the Honorable Supreme Court. The Learned Counsel has also relied upon judgment passed by Honorable Delhi High Court in 2022 SCC online Delhi 2621 and has referred to paragraph 40 to 45 of the same judgment. The Learned Counsel submits that the case of the petitioner is squarely covered by the judgment rendered by the Honorable Supreme Court in the case of Ram Kumar Gijoya, and in view of the present writ petition is fit to be allowed. Reported in 2016 bracket close 4 SCC 754. This is your summary you have given in your written submissions.
Yes.
The summary of the arguments advanced by the petitioner is also reflecting from the written submissions filed by the petitioner, which is quoted as under. Thoda sa is summary ka portion, the relevant portion is quoted as under. The Learned Counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that the petitioner is bound by the terms and conditions of the advertisement. He has referred to the advertisement contained at Annexure 4 and has submitted that as per the vertical reservation, different reservations have been provided for BC1 category and BC2 category. He has also submitted that he has also referred to clause 10 of the advertisement to submit that the caste certificate was issued in terms of the prescribed form Roman 2, which was in terms of the circular issued by the state government contained in letter number 1754 dated 25/2/2019. And it was also indicated that the said format was available on the website. The Learned Counsel submits that the format was prescribed not only to indicate the specific category in which the candidate was belonging, whether BC1 or BC2, but also indicating as to whether the candidate belongs to the creamy layer or not. The Learned Counsel has referred to clause 12 of the advertisement and has submitted that although initially at the time of filing online application, the certificate was not required to be uploaded, but on the basis of the but the certificate was required to be, but hard copy of the certificate was to be submitted at the time of filling up the form for mains examination. The Learned Counsel submits that the certificate which was to be submitted in the mains examination was the same certificate which was available to the candidate at the time of filing the initial form. He has further submitted that the clause 12 of the advertisement further indicates that once the application is submitted, once online application for mains examination is submitted, the required certificate was to be produced at the time of physical verification of the certificate, and he submits that this also related to the same certificate which was referable at the time of filling up the forms. And the clause 12 also indicates that any certificate that after the date of verification, any certificate if produced will not be accepted.
On the date of verification, any certificate or
हाँ.
any other certificate which is not mentioned.
Okay. इसको ठीक से लिखिएगा. The Learned Counsel submits that on the date of verification, any other certificate which was not issued on the date of filling up the form was not to be considered.
And not mentioned in the online application.
And not mentioned in the online application. He has also submitted that the advertisement further clarifies that once the application is submitted online, no changes would be admissible. The Learned Counsel has again referred to the prescribed form in which the certificate was to be issued. The Learned Counsel has further referred to Annexure 6 of the writ petition to submit that on 15/9/2020, the documents were to be produced for physical verification, which included the caste certificate in the prescribed form indicating as to whether the candidate belongs to BC1 or BC2 category. He submits that the reason for rejection of the candidature of the petitioner was rightly passed. He has also referred to the rejoinder filed in the present case.
Supplementary counter.
So yes, the supplementary counter affidavit filed in the present case, paragraph 6 and 7, and has referred to the annexure thereto, and submits that the candidature of the petitioner was rejected by indicating, quote, no, within bracket, form 11 not annexed, issue date after hard copy submission last date, bracket close, earlier caste certificate in central government format submitted at the time of hard copy submission.
Dated 29.
Dated 29/2/2020. Format dated 29/2/2020, submitted at the time of hard copy submission. Inverted comma closed. The Learned Counsel has referred to the judgment passed in LPA number 169 of 2015, decided on 1/9/2015, contained at annexure Roman 7 to the written submissions, paragraph 2 and 4, he has further referred to the judgment passed by Honorable Supreme Court, Annexure 1,
Annexure 1, Supreme Court, Dipya.
WPS.
नहीं, my lord, WP that is on the single judge of the coordinate bench. Your
Okay,
lordship. That is your
has
lordship.
referred to the
Annexure-
judgment passed by this court in WPS number 863 of 2023.
869 of
Sorry,
2020.
869 of
Of
2023
Annexure
contained that
Roman
annexure Roman
15 your lordship,
Roman 15
of the written notes of.
of the written notes of written notes of argument. He has referred to paragraph 5. Sorry, which paragraph is this?
3 your lordship.
Paragraph 3, 7, 9, 12, 54, 55, 56 and 57.
My lord, that is on Supreme Court judgment. Your lordship.
Okay, इसमें लिखिएगा paragraph number 3,
4,
4,
6,
3, 4, 6,
then 7,
6, 7,
10,
10,
11,
11, 12. Para 3 to 12.
and your lordship.
He has also
20 is also important, your lordship, and thereafter 5 minutes. 20 and 35, 36.
para 20 and 35.
36.
35, 36. Para 3 to 12, 20, 35, 36. He has also referred to judgment passed by this court in LPA number 91 of 2020, decided on 21/10/2022. The learned counsel has also relied upon the recent judgment of the Honorable Supreme Court in the case of
Dipya.
J.K. Maheshwar, Divya versus Union of India,
And others.
reported in bracket 2024 bracket close 1 SCC 448, and has referred to paragraph 5.3, 7, 8,
7, 8, 9,
7, 8, 9,
12,
12,
14,
14, 54.
14 your lordship.
Yes, 14, then 54.
No, your lordship. Then your lordship, I am coming, your lordship.
You have to read just the ratio of the judgment. You
Your
can't
lordship,
read the case of the
33,
petitioners.
33, 35, thereafter your lordship.
These are all submissions.
Then your lordship, I am coming, your lordship.
Paragraph
Your
number
lordship is correct,
54.
54. Your lordship is correct.
Paragraph
I am
number
sorry, your lordship.
54, 55, 56 and 57. And has also further referred to paragraph number 61 of the state judgment to submit that the parties are governed by the terms and conditions of advertisement, and the judgment passed in the case of Ram Kumar Vijaya has no applicability to the facts and circumstances of this case. In response, the learned counsel for the petition has submitted that the judgment passed by the Honorable Supreme Court in the case of Ram Kumar Vijaya has been considered in
In the case of Kranti Singh Yadav
the case of Kranti Singh Yadav
versus
versus
Government of NCT Delhi,
Delhi,
In-
reported in
it is SLP Civil 14948
SLP Civil.
14948 of 2016.
Where is that order?
I will just give a copy
You don't put it on record.
because when it was referred that in another judgment has been considered, then I could find it out here. I I will give it. I have got a copy and everything.
That is judgment of 2023, latest judgment, Divya.
And this is a 3-judge bench where it has been quoted with approval.
You see, if you do not give that
But
copy
Karan
right
Singh-
now,
Karan Singh Yadav, your lordship, that has been taken note in the Divya case, your lordship. Karan Singh
I will
Yadav.
give it. I will give it.
Reply,
I will
reply.
give it right now.
you give it right now. If you don't give it, then this will not form a part of the dictation also. Right?
But Karan Singh Yadav case has been considered in Divya case, your lordship. I have.
Arguments are concluded. Post this case for judgment on Twelfth of March.
But in para 56 of Divya judgment, that judgment has been taken note. Karan Singh Yadav. Of that, your lordship.
Madam, when you type it out, you ensure that whatever dictation is given, right, and the paragraphs which they have referred to should be properly quoted.
Item 2, WPS 4607 of 2023.
When you go back, you just type this order at the threshold and give it to me in the lunchtime. File which volume is? Yes, petitioner.
Leadership on number 3. This matter may be kept there for tomorrow, leadership.
Why are you seeking? You are seeking a judgment. Why?
It will be argued by Minal Council.
You don't give advance adjournment slips.
Lordship, I have seen instruction from Court Martial Lordship yesterday that
He will instruct you.
Yes, Lordship, I was going to give a advance notice, Lordship. I have also sought instruction from Court Martial.
You just come to page number 72. This is the impugned order
Yes, Lordship.
part. You see the Roman 3, what is it?
Any अभियंता सैनिक सहायक अभियंता सैनिक के पद पर दी जाने वाली नियुक्ति WPS नंबर स्वयं जो सिपाही को अंतिम न्यायाधीश प्राप्त
So these matters are pending.
taking section Lordship. because
You
this matter
have to
has
say, take instructions whether these cases are pending or not.
Lordship, this matter has to be argued by Senate Council Mr. Ajit Kumar Lordship. If
No,
the-
you see when
Actually,
देखिए
this
तो
coming
just
in
please
form
hold
that
on.
he will take time, Lordship.
Please hold on. WPS number 3027 of 2016 देखिए तो pending है क्या?
3027.
हाँ of 2016.
This matter will keep after one case Lordship will commence in versus Lordship.
3027 of 2016.
Pending.
Pending है ये 3750 of 2022. 3750. Pending है 2022. 3750 of 2022. Pending है ना तो ये केस नहीं डिसाइड हो सकता unless these cases are decided. You mention this case after the disposal of these cases. We can't do anything about it, right? देखिए WPS number 4607 of 2023. Counsel for the parties are present. As per the impugned order, as per the order impugned in the present case, the same is subject to final result of WPS number 3027 of 2016, semicolon, WPS number 3750 of 2022, semicolon, WPS number 4093 of 2022, semicolon, WPS number 5130 of 2022, and WPS number 5131 of 2022. considering which is reflecting from paragraph number Roman 3 at page number 72 of the impugned order. Considering this aspect of the matter is directed to be listed. Office is directed to place this case after disposal of the aforesaid writ petitions. Or on 2nd of September 2024, whichever is earlier.
For orders with defect, item 4, WPL 2970 of 2020.
Sorry, but I have removed all the defects, defect number 2, 7 and 11. And why defect number 6 has been pointed out, though I had already removed that. Today I have removed, I have filed the, with regard to the defect number 2, 7 and 11.
What is your case? Are you ready?
Today I am not ready. This is related with the majority of input recommendation, I said argue to matter.
Tomorrow?
No, tomorrow, no, next week. In the next week I said argue.
According to you, you have removed all the defects.
Yes, according to me, I have removed all the defects.
I will
But-
pass a preemptory order.
6
You have removed
defect number 6 I have already removed, but this is also, it has also been pointed out. That is the 2, 7 and 11 I have removed, and 6 I had already removed, but it is showing still showing that this is
There are
some
many
heavy
defects which are still showing.
Uh,
2,
de-
6, 7, 11.
2, 7 and 11 I have removed, and 6 I had removed, but it is still surviving. तो हम देख लेते हैं, इसको वेरीफाई करना 6.
The learned counsel for the petitioner submits that all the defects in the present case has been removed except defect number 6.
Yes.
He submits that the said defect be ignored. Right? Let's ignore it. Considering the aforesaid submission, that the defect in connection with defect number 6 is hereby ignored for the present. Pose this case under fresh filing on Monday.
On 13th,
आपके हिसाब से date नहीं हो सकता. You don't remove the defects for years together.
yes, yes. Of course, Mr.
Otherwise, I would have normally
Yes.
passed a preemptory order. But since you are saying, so I am not saying anything.
Item 5.
13
Item 5, WPL 428 of 2023.
Okay, 13th. If you want 13th, it's okay. Let it come on 13th. No? Petitioner? Time till 19th March is granted to the petitioner to remove the surviving defects preemptory. If the defects are removed within the stipulated time, pose this case on 16th of April under application.
Item 6, WPS 524 of 2023.
petitioner. WPS number 524 of 2023. Considering the nature of defect. You have filed your counter affidavit in this case? What is the nature of relief? Considering the nature of defect pointed out by the office and the fact that there are other representations which have been placed on record, the surviving defect as pointed out by the office with reference to defect number 4 is hereby ignored for the present. The learned counsel for the respondents are directed to seek instruction and file a counter affidavit in the present case. Close this case on counter affidavit by 3rd April, rejoinder by 10th, post on 16th April under the heading for revision.
Item 7, WPS 1701 of 2023.
Defect including the court fees.
Item 7,
Who's for the petitioner? Who is for the petitioner? ये वाला एक ऑर्डर का कॉपी चाहिएगा 2072 of 2007 2072 of 2007. Let's see if it is there in this case. 2072. ठीक है 2072 of 2007 decided on decided on 23/12/2015. Nobody appears on behalf of the petitioner. the surviving defect is hereby ignored for the present, post tomorrow under the heading of fresh filing. केस का नंबर मिला ऑर्डर निकाल लीजिए मंगा लीजिए ऑर्डर लगा के इसमें लगा लीजिए
Item 8, WPS 1746 of 2023.
There are two surviving defects. One relates to proceed. So please note 2 weeks time. This relates to regularize.
Counsel for the petitioner prays for and is granted time till 4 weeks. I can't give you 4
2
weeks.
weeks.
Time till 20 तारीख का डेट दिया 19 तारीख का डेट दिया
Yes.
अभी एक सिमिलर ऑर्डर में 19th March. Preemptory order till 19th March. If the defects are removed within time, it will come on 16th of April. What is this IA for?
IA for deletion of 3 names from page.
Should I do that? So far as IA number 4878 of 2023 is concerned,
For deletion,
petition has been filed for deleting the name of the petitioner number
3, 5 and 7.
3, 5 and 7 from the cause
Yes, sir.
title of the present case. Any reason?
The reason they do not want to proceed.
They do not want to proceed with
In
the
this
present case. Counsel for the respondents has no objection to the prayer for interlocutory prayer made through the interlocutory application. Accordingly, IA number 4874 of 2023 is allowed. The learned counsel for the petition is directed to delete the name of
3, 5 and 7.
petitioner number 3, 8, 5 and 7 in the cause title in red ink during the proceeding.
Item 9, WPS 1747 of 2023.
Who is for the petitioner? Considering the nature of defect pointed out by the office, the same is hereby ignored for the present. Pose this case under fresh filing tomorrow. Counsel for the petition is absent.
Item 10, WPS 1748 of 2023.
Same order. Just a moment. Let me just check. चलिए सेम ऑर्डर कल फ्रेश फाइलिंग में जाएगी.
Item 11, WPS 1777 of 2023.
Yes. The surviving defect is in connection with annexure 2 to the writ petition, right? (28) and 29. Which page number you are not aware?
No, annexure 1, annexure 2, and also annexure 3, first 2.
page 25, 26, 27.
The learned counsel for the petitioner submits that the surviving defects are in connection with annexure 1, 2 and 3, which are essentially the documents of the respondents. These are all your documents, right? These are all your documents. Yes. Considering the aforesaid aspect, the defects in connection with the aforesaid pages is hereby ignored for the present, and the learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case, annexing the legible copies of the aforesaid 3 documents. The counter affidavit be filed by 19th March, rejoinder by, what's the date? Rejoinder by? The counter affidavit be filed by 19th March, the rejoinder by the counter be filed by 3rd April, rejoinder by 10th March, post on 16th April. Right? Under the heading for admission. You annex those documents, you will not be able to type it out also properly. If it is not available, you mention it in your counter.
In the counter affidavit, you mention.
Item 12, the nucleus 1778 of 2023.
Where is the petitioner? इसमें preemptory order. Counter affidavit has been filed. There is nothing. There is nothing in the petition. They may not even remove the defect. Let the time to remove the defects by 19th March. If the defects are removed within the stipulated time, post this case under appropriate heading on 16th of April. Preemptory order.
Item 13, the LPS 1795 of 2023.
Yes, petitioner.
Item 13. Item 13.
Who is an item number 13?
Type of A has to be filed in page number 22, 23, 45, 48 and 50.
What is the matter? Argue your case.
Device case
You argue your case, please. Argue your case.
leadership he joined.
He has filed. They have filed a counter affidavit.
Yes.
Are you ready? You get ready. We'll take it up at 2:15.
Item 14, the LPS 1796 of 2023.
In this case, the office has pointed out 4 defects. Defect number 1 is deficit port fee of 450 may be filed. With regard to this defect, within 1 week we will file the deficit port. With regard to defect number 2, type copy of Annexure 1, series may be filed. Because Annexure 1 series is the prescription of the document. And the type copy with regard to that, we are praying that this defect may kindly be ignored. Because the prescription of the document, in my humble submission,
These are irrelevant documents?
in my humble submission, only with regard to the element of the petitioner, the document of Annexure 1 series was filed.
You delete it. The
Kindly-
documents which
kindly
we
be-
cannot, you
kindly be
delete it.
ignored. I know.
You delete it. You delete it.
Ignore कर दिया जाए kindly.
Ignore नहीं कर सकते. Any document which is illegible cannot be ignored. You can delete it if you want.
टाइप कराने की कोशिश कर रहे हैं लेकिन
I know. So any document which both of us cannot read is of no use.
कोशिश करते हैं फिर टाइप कराने का बाद देखते हैं अगर हो जाता है 2 पेज खाली नहीं और डिफेक्ट नंबर 3 है in the prayer number 1 we have prayed for quashing of the order passed in revision and 5 is also connected to that. The number of revision is not mentioned in paragraph. Minus we have filed.
No, document order which is under challenge has not been filed.
Yes, we have not minus we have filed IA petition to delete prayer because of the reasons no revision was filed due to inadvertence that prayer was
So
made.
IA for prayer number 1 and prayer number?
Prayer number 3, prayer number 1 to delete that prayer. Then that will suffice, my lords, defect number 3 and 5 both. Right? Roman 1 का Roman 1 prayer. इसीलिए आइए फाइल किया.
You have filed a revision.
No, not filed.
You have
That was-
stated so in para number 18.
Minus. We have not mentioned the number in.
No,
para
but you have stated that you have preferred a revision.
Yes, but that is not in my humble submission due to inadvertence. It was mentioned that revision was filed. But minus, in IA we have categorically stated.
That no revision was filed.
Minus, no repeat. No.
Where is it?
That is minus in IA number 9135 of 2023.
Where is it mentioned that you did not file any
Yes.
revision?
For 1 we have stated that the petitioner is filing this IA petition for deleting the prayer made at para 1 Roman 1 of the writ petition as well as prayer made at para 1 in the prayer portion of the writ petition as well as in the statement made at paragraph 18 of the writ petition wherein it has been mentioned by the petitioner that it
Just a
being
moment. WPS number 1796 of 2023 with IA number 9135 of 2023. The learned counsel for the petition has submitted that interlocutory application has been filed to delete the prayer number 1 within bracket Roman 1 as well as prayer at as well as prayer portion at within bracket Roman 1 as the petitioner never filed any revision application against the order
necessary.
dated 16/11/2021 and therefore the question of quashing of the order passed in revision does not arise. He submits that consequently the defect in connection with paragraph number 18 of the writ petition as well as annexing the order of revision through supplementary affidavit does not arise, right? Considering the aforesaid submission, IA number 9135 of 2023 is allowed. The petitioner is directed to delete the prayer number 1 within bracket 1 as well as prayer portion at within bracket 1 of the writ petition in reading during the course of the day. The paragraph number 18 of the writ petition is also directed to be deleted, and the surviving defect in connection with filing of supplementary affidavit is ignored. This is subject to, have you filed any counter affidavit in this case?
Yes, Lordship.
Have you stated that they filed any revision?
Lordship, that is there, Lordship. पता नहीं वो लोग भी कैसे लिख दिए?
नहीं फाइल किए हैं?
नहीं लिखे हैं कि फाइल हुआ है।
आपके काउंटर में क्या है?
कि रिवीजन फाइल हुआ है, but no number, no year कुछ दिया नहीं।
Have you stated in the counter affidavit that revision was filed?
Yes, Lordship.
Where is it mentioned?
काउंटर है Lordship इसमें है। काउंटर का Lordship पैरा 23।
कॉपी दी है हमको।
Where is the counter affidavit? Not filed.
फाइल नहीं हुआ।
This is IA. This is supplementary.
They are not such a copy.
You have not
verify, but I have the copy. I will verify it.
Considering the aforesaid submissions, the surviving defect in connection with filing of supplementary affidavit and the aforesaid prayers. नहीं, आधा कुछ लिखा है आपको, are hereby ignored for the present, subject to any counter affidavit that may be filed by the respondent. अगर फाइल किए हैं ये revision, तो revision का कॉपी लगा दीजिए. They can't have it both ways, right? So far as the other defects are concerned,
एक सप्ताह फाइल कर देंगे हम लोग कोर्ट फ्री। डिफेक्ट नंबर 2 जो है।
so far as the other defects are concerned, let them be removed by 19th of March. Preemptory. If the defects are removed within stipulated time, post this case on 16th of April.
If they have filed counter affidavit, they will serve direct action we give to serve.
अभी काउंटर का अभी तो आपका डिफेक्टिव पिटीशन
कॉपी बोल रहे हैं कि फाइल किए काउंटर
नहीं
I will verify as
दे
well.
हैव नॉट फाइल्ड
मेरे पास था कॉपी हो सकता है फाइल।
नहीं हमारा कंप्यूटर इंक्वायरी बता रहा है
इलेक्शन 1 का जो टाइम कॉपी की प्रीएम्प्टिव टाइम दिया था
फाइल्ड है Where is the counter? इसमें लिखिए the surviving defect with regard to filing of typed copy of Annexure 1 is
Annexure 2 Annexure 1 yes
Annexure 1 series, which are prescriptions of the doctor and medical documents, are hereby ignored for the present. A counter affidavit has been filed in the present case, indicates that आप आईए का काउंटर फाइल करें, आईए का काउंटर फाइल करें।
Yes,
If they have filed their revision, you annex the memo of revision and the order of revision. Then we will take care of it.
क्योंकि काउंटर में भी वो लगाया नहीं, बस स्टेटमेंट है.
और आपने भी काउंटर में स्टेटमेंट दिया है कि इनका रिविजन डिसमिस हो गया. कहाँ से दिया है वी डू नॉट नो. इसको लिखिए तो फिर से you just take it down. WPS number 1796 of 2023 with IA number 9135 of 2023. Interlocutory application has been filed for deleting certain prayer in the petition by stating that the petitioner never filed any revision against the order dated 16/11/2021. A counter affidavit has been filed in the present case stating that the revision against the said order has been dismissed, but neither the copy of the memo of revision nor the order of revision has been annexed by the respondents in the counter affidavit. The learned counsel for the respondents is directed to seek instructions and file a supplementary counter affidavit in the present case annexing the memo of revision as well as the order passed by the revision authority. Needful be done.
If it is filed, it's okay.
We do not know. How do you mention it in the counter affidavit? You have mentioned it.
Yes.
You file it. The needful be done by 15th of March. Post this case on 18th of March under the same.
कोर्ट फी हम लोग एक हफ्ता में फाइल कर
File कर दीजिए. In the meantime, the petitioner is directed to file the deficit court fees.
प्रेयर जो है डिलीट करने वाला तब तो फिर अभी जब फाइल करेंगे उसके बाद
हाँ, इसीलिए वो रिकॉल करनी है.
ठीक है
आइए का जवाब आएगा
कोई
उसके बाद.
दिक्कत नहीं है ये फाइल कर दो मैं हम आई विल वेरी मच
That's right.
Item 15, WPS 1946 of 2023.
Petitioner.
My lordship, there is a small prayer. Submission is that I want 4 weeks time. There are certain defects that I will remove.
Why do you need 4 weeks time to remove these defects?
There are certain defects that you have to remove.
No, we just can't keep on giving time. You don't remove the defects, you don't appear before the registry. No one appears. Same order. Time till 19th March is granted to the petitioner to remove the surviving defects preemptory. If the defects are removed within the stipulated time, post on 16th of April under application.
Item 16, WPS 2282 of 2023.
What is the relief that you are seeking? Yes, respondent, you dispose of this representation.
There are certain facts that has not been filed and brought on record and that has been suppressed. Beloved, there is already an order of compassionate appointment to his son. And as far as retirement benefits are concerned, she has not vacated the quarter even after the death of
You file your counter
I need to file a counter.
and so far as the defects are concerned, it is typed copy of annexure 2, order number 1. Let's ignore the defect.
No issues. I think
No
I'll
issues,
be-
yes.
Let me.
WPS number 2282 of 2023, counsel for the parties are present. Considering the nature of defects, the nature of surviving defects, they are ignored for the present. Learned counsel for the respondents is directed to seek instructions and file a detailed counter affidavit in the present case. She submits that the petitioner has suppressed material facts. Let the counter affidavit be filed by 19th March. By 19th March, rejoinder if any by the rejoinder, if any, by 2nd April. Post this case on 9th of April under the heading for admission. Let it be under the heading for final disposal. Everything will be there.
Luckily, I had received the instructions. Otherwise, again, representation would have been disclosed and the right would have accrued in his favor. That's right.
Final disposal.
Item 17, the LPS 3403 of 2023.
What is the defect?
There are 3 defects. One type of
And what is the relief you are seeking?
That is relates to amendment of liability.
What is it? What does that mean? What is the kind of relief you are seeking? You participated in the selection process?
Mercy.
Your candidature was rejected?
Rejected mercy.
Also for the parties are present. Counsel for the petitioner prays for and is granted time till 19th March to remove the surviving defects preemptively. If the defects are removed, pose this case on 21st March under appropriate heading. In the meantime, you can file your counter.
We have received a statement.
You have received it. At this counsel for the respondents has submitted that he has already received the instructions and it will be open to the respondents to file their counter prior to the next date.
Item 18, WPS 3452 of 2023.
Yes, petitioner. Leave encashment.
Leave encashment done
Till
currently
2001.
2001.
What were you doing?
Some of the producer retired in 2020, 21, 23.
How many persons are there?
There are 6. All of different date
You
of
considered
retirement.
their representation because the matter was absolutely fluid for quite some time, decided later on. But of course, regarding the details of leave encashment and supporting documents, they will have to furnish.
It can be disposed.
It can be disposed of.
Dispose of it.
Who is the authority who will take the decision?
District Education Officer Giridi.
The learned counsel for the court fees का डिफेक्ट तो नहीं है ना? There is no defect regarding court fees, I suppose. That I cannot ignore. You don't see the file also.
There
Need
was
the
a-
assistance
there
of
was
the
a
court.
defect related
There
to
is a
from
defect
out
of court fees.
2,500.
You deposit court fees, but during the course of the day, we will dispose it of tomorrow.
And I will.
Rest we can forget.
And one submission, Manish. In my humble submission, the director should be.
We'll take
because the petitioner have not stated where they
We'll
have.
take care. You can just simply say that the director should be the person to whom he should represent. The learned counsel for the parties are present. Counsel for the petitioner undertakes to remove the defect regarding court fees of rupees 2,500 during the course of the day. Considering the nature of relief, the surviving defects are ignored for the present. Post this case tomorrow. You file it, we'll dispose it of. नहीं, कल ही ऐसे defect नहीं रहेगा. If you file it, then it will come for fresh filing.
I will file that.
You file the court fees. It will come for fresh filing if you file it.
Item 19, WPS 4350 of 2023.
Yes, petitioner. It is a defective petition.
The first two defects in the issue relates to that counseling matter, my lord. The first two defects, if my lord feel that it could be ignored, because that is regarding typed copy and fresh copy, my lord. And the other three defects that I am doing right now, I have corrected.
We'll dispose of the matters in terms of the orders passed. That should be sufficient.
Your Lordship, this is the second round litigation. Second round litigation.
Whatever it is only in terms of those. Second round.
Second round.
They have participated in the
We have
council.
taken, Your Lordship, after passing of the order by this honorable court, a decision has been taken by the Department of Justice, wherein we have clarified the position with regard to the petitioner that he has obtained lesser marks than the last selected candidate. That's why his candidature has been rejected.
Now, may I now clarify, what has happened, my lord? In 2019, when my name...
There is no question of fresh counseling, no?
No, fresh counseling is going on, my
No,
lord.
it's going on for those persons, no?
Here I was not allowed to participate.
Where have you stated that you were not allowed to participate?
That is their own objection also.
Where have you stated that you were not allowed to participate?
Page 46. Page 46.
No, it's from the writ petition.
Page 46.
From the writ petition.
From the writ petition. Yes. Para 10, the counseling of different districts was scheduled for different dates. However, the petitioner was not allowed to participate in the counseling by the members of the counseling team and DSC on the ground that the petitioner being a para teacher could have applied in non-para category only, could not have applied in non-para category and demanded his resignation from the post of para teacher. Then only he can be allowed in counseling in non-para category and thus shown the petitioner.
Where are you stated in the counter affidavit?
Now 46.
Just. Where have you stated in the counter affidavit?
Your Lordship,
With regard to para number.
Para number 10 is denied.
Denied means?
We have simply stated Your Lordship's statement pending para number 10 of the writ petition is denied, and it is submitted that the writ petitioner has not submitted any document in support of the statement pending para number 10 of the writ petition.
What document will they submit? Where they called for document, where they called for counseling. This you need to verify from your records. Therefore, in terms of division bench, 2 orders, right? You have simply denied it. You need to verify everything from your records with regard to each of the petitioners. If you have called them for counseling, then under such circumstances there is no question of fresh counseling.
Your Lordship, one paragraph is also from my counter affidavit and paragraph 14, that so far as the statement in para number 12 and 13 of the writ petition, it is submitted that the writ petitioner was not covered by the order/judgment passed by the Honorable Court in LPA number 186 of 2017 and LPA number 119 of 2017.
It is one thing to say there was a lot of dispute whether para teacher or non-para teacher they can participate, not participate. You verify the record, you tell them that you were called for counselling and you did not qualify. Simple. Right? Or otherwise also, if they have got less marks, they will not be called for counselling. As simple as that. Heaven is not going to fall.
Yes.
Right? Otherwise also in all the orders we have said that because the foundational facts in the writ petition are not clearly stated in many of the writ petitions. So I will just refer to his para number 10 and then your reply and then dispose of it in terms of it. Okay. WPS number 4350 of 2023. Court fees का कोई defect नहीं है?
नहीं, court fee का नहीं.
This writ petition has been filed. The learned counsel for the parties are present. This writ petition has been filed for the following relief. There is Annexure 7, which is the improving order.
Page 49. Madam.
You had moved this court earlier also.
Yes. That is an extra one, madam.
Kindly read your order first.
Yes, madam.
Let me just, it's a defective petition, I have not gone through it. Yes, please.
May I read it? Page 28. Where we have quoted the positions of petition upon the concerned respondent, showing them all is to worry under what circumstances the petitioner was shown qualified for counseling schedule for 2015 for district Bhopal, were not entertained allowed to participate in counseling for the post of entertained teachers in non-para category in connection with the advertisement issued by concerned respondent, although the candidate having lesser mark than the petitioner were allowed to participate in the counseling. Further, prayer petitions of direction upon the concerned respondent to issue letters of appointment to the petitioner for the post of intermediate trained teacher, since the petitioner has qualified for different districts and were called also for counseling, but they were still not allowed to participate counseling on the ground the petitioner has not obtained the judicial order as well as petitioner is para teacher, therefore it can be considered only in para category and not in non-para category. Now, I'm just skipping relevant.
Just a moment. There was one more judgment passed by learned single judge, that the judgment passed in 186 is to be extended to even those persons who were not party in that petition. Right? So that has also not been considered in your improved order. I'll pass a proper order tomorrow, otherwise you will do the same thing again. Right? Likhiye WPS number 4350 of 2023, the learned counsel for the parties are present, considering the nature of relief and also the nature of surviving defects. The surviving defects in the present case are ignored for the present. A counter affidavit has already been filed in the present case. Post this case tomorrow under the heading of filing. कुछ छूटा हुआ है आपके improved order में.
Item 20, WPC 4615 of 2023.
So there is no defect, it has come in a list of defects. On 5/1/24, the direction was issued to the district to file counter. Subsequently on 13/2/24, again direction has been issued.
WPC हमारे पास कैसे आ गया? This is wrongly listed. This matter has been wrongly listed before this court, post this case before appropriate bench as proposed to be.
Item 21, WPS 6390 of 2023.
There's one minor defect, which is only the date has not been mentioned before the prior portion. Otherwise, all defects are removed.
Date may be mentioned below the signature of the.
That is all.
Forget. What is the
Otherwise,
matter?
now they are asking for one increment. Now they have said that since we have already retired, and now Honorable, there is a decision which I have annexed as Annexure 3 by the Honorable Supreme Court. We say a person who has already covered here. Normally the increments are granted when a person.
It is a monetary compensation.
It is a
monetary relief.
Monetary relief where a person who is retiring on 30th of June will be given one increment. Is the decision Madras High Court and the Supreme Court also that I have already annexed. Our representation.
Sorry. You want disposal of representation?
Others they can file it. There are two matters today.
You consider it. You consider all these judgments also.
Yes,
it is basically monetary benefit,
Yes.
not a kind of a promotion. It is basically monetary benefit arising out of completion of a particular length of service.
Yes.
Have they passed any order?
No, they have not passed any order. Rather, they have not even considered.
Whom have you represented?
We have represented on Annexure 1 series, Your Worship. On 15th of June 2023. On 3rd of July 2023.
Show me one representation from where I get the entire facts.
Annexure 1, page 18 onwards. Annexure 1 series.
Give me one representation, not all. And who is the authority who will consider your
Secretary
demands?
Road Construction Department. One may consider the last representation. Represented is 8/5/2023.
You have never been given this annual increment.
One increment. We are given all increments. What has happened? If
One
we retire-
increment which was due on?
It was due on 1st of July 2023. I retired on 1st of July 2022. There are three petitioners also.
Just a moment. You retired on 1st of July 2022.
I retired on 38th of June 2022.
30th June 2022.
22.
Yes.
My increment was due on 1st of July 2022. After one.
After one day.
Yes. Post retirement means I have already completed 1 year service. This is what the Supreme Court has considered this matter. Any person who was then in service, on 1st of July of any subsequent year, one increment is granted to any government employee. Now what has happened? If I consider my date of retirement, on 1st July
These authorities
2021.
will not be able to decide it. You file your counter.
Let's see.
Thank you. WPS number 6392 of 2023. Considering the counsel for the at the request of the counsel for the petitioner, the surviving defect. You remove it during the course of the day.
I'm just adding.
The petitioner is permitted to remove the surviving defects during the course of the day. The learned counsel for the respondents is directed to seek instructions. Who will give the instructions? Give us some higher authority should give the instructions. One. Seek instructions and file a counter affidavit. Who is for AG? You also file your counter affidavit. The learned counsel for the respondents are directed to seek instruction and file a counter affidavit in the present case, taking into consideration the judgments which has been relied upon by the petitioner and annexed with the writ petition. The counter affidavit be filed by 19th March. The rejoinder, if any, by 2nd of April, post on 3rd April under the heading for final disposal.
Similar case is listed at serial number 32.
32.
30.
30 defective.
नहीं this is first line.
Okay. 30 में भी सेम ऑर्डर कर दीजिए. डिफेक्ट का खाली नहीं रहे.
उसमें डिफेक्ट नहीं है.
Same.
Exactly.
Let this case be tagged with WPS number
7486
7486
of 2023.
Which is that serial number?
30.
7486 में लिखिएगा. Counsel for the respondents are directed to seek instructions and file counter affidavit. Same timeline and same.
Item 22 WPS 6591 of
I will take down the defect note. By undertake to remove by 19th note, and regarding port fee, I will deposit it by tomorrow.
Let the surviving defects be removed by 19th March preemptory. If the defects are removed within the stipulated time, post this case on 16th April under appropriate heading. If you want to file your counter, you file it. In the meantime, the respondents to seek instruction and file a counter affidavit in the present case.
For orders, item 23, Tribunal Division 90 of 2019.
What is it?
Notice was issued upon the opposite party number 2 in the last.
Provisional bail, when was it granted? It's extended till 22/3.
Yes, initially it was granted.
On what ground was it granted?
The grounds that was raised in the criminal revision,
No, what
apart
is-
from the fact that
What is
yes,
the ground?
An IA was filed. An IA was filed.
IA
on
was-
that, yes.
Where is
That
that
has
IA?
that has been disposed of. It was a prayer for bail and
So
that
now
was-
the provisional bail the period has expired.
No, it has not expired. It is still 22/3/2024. I am only praying that the bail may be confirmed. My prayer is that the provisional bail may be confirmed, because the fact is that now I happen to be the second husband. Initially, the petitioner opposite party number 2 had performed a marriage. She filed a case against him, gets a divorce. She marries me, files a case against me, gets divorced, and in 2015 she has again married for the third time. She has again performed a marriage. I have filed a supplementary affidavit to that effect also, bringing that fact also on record. And that is perhaps one of the reasons why she is not interested in appearing in this matter.
You have been convicted under section
498 and 3 and 4 of the dowry prohibition.
both 3 and 4.
Yes.
What is the minimum sentence in 3 and 4?
Sorry, I'm not carrying the bear at Mullers.
You come with the Bear Act.
Mullers.
You come with the Bear Act.
Mullers.
There is a minimum sentence also. You have been released just on provisional bail. What should be done?
Mullers, but so far as my revision is pending, Mullers, my prayer is that my bail may be confirmed
You
and
can
it may
argue
be
your
heard
revision.
finally.
You can
Mullers, in the
finally
second-
argue your revision application to it. Argue. We are ready to hear it. You argue your case. Right. What is the minimum sentence under section 3 and 4 of Dowry Prohibition Act? दिखाइए जरा उनको. What is the date of incident? दिखाइए.
I'm praying that if it may be listed on Thursday or Friday, Mullers, then I can finally make my
The respondent could not be found. So you will undertake paper publication.
That will be
उनको दीजिए. He needs it more. Three is 5 years minimum sentence, and 4 is perhaps 6 months.
But under 3 and 4, I have been given a sentence of 6 months.
They have given you, but we do not know. But minimum sentence at least 6 months is all certainly there.
6 months is there, and that has been passed.
How much have you remained in custody?
So far as initially I was convicted, and thereafter I preferred an appeal, and thereafter I was arrested. On 8/6/2023, I was taken into custody, and thereafter this honorable court has granted me bail on 9/11/2023.
LCR has already come.
LCR, yes, it was called for.
It is already there. आ गया ना LCR?
Yes, yes.
This is arising out of the complaint case.
This is arising out of an FIR.
So as it is, you can hear the matter.
Let it come on.
Because she is traceless now.
Yes, she has performed her third marriage. She has performed her third marriage.
But as per the record, she is not available. You have not given the correct address. If you know her correct address.
Because now I am completely not in touch, because in 2015 only she has married, and she must have been residing with her husband. So that is, if your lordship may permit, then I'll file requisites for paper publications.
Criminal revision number 90 of 2019. In spite of notice issued to the opposite party number 2, there was a service of notice through the concerned police station.
Yes, through the state was also.
They have filed their affidavit.
No, I have not.
Who is for the state? Call the state. We'll ask them to file an affidavit.
Mr. Suraj Dev.
Please call him. Call him in a second. We'll ask him to file an affidavit to that effect, and then you file your petition for substituted service. You come in the second.
For press filing, item 24, WPS 6053 of 2018.
Petitioner.
Yes, ma'am. Prayer is to cause an actual court that is now passed by the district court.
Section 4,
Yes, ma'am. Page number 37.
what is the perversity in the above?
The time frame for filing an application for compassionate ground is 18 months. Here in this instant case, it has been filed after around 3 years from the date of death. But the tribunal says you take a sympathetic view and you give
Let
it.
us see.
Yes. Let's- Page number 38. The short point to be decided in this reference that the deceased workman dependents and who applied for job is entitled.
Page number
38. Second page of the award.
30,
Running page number 38.
38,
Second page of the award.
37, 37, and then you have not a next page number.
So supplementary affidavit has also been filed.
Yes.
Yes. The short point to be decided in this reference that the deceased workman's dependent son who applied for job is entitled for job or not. The applicant is the deceased workman's son, that is of Roshan Bhoni, ex-wagon loader who died during his job, that is 11.
WPL number 6053 of 2018. The learned counsel for the petitioner submits that the learned tribunal, by passing the impugned order, has granted compassionate appointment to the son of ex-employee by taking a sympathetic view, although the application was filed beyond the prescribed period as per National Coal Wage Agreement.
No, it's a circular by Coal India.
Okay.
It's a circular.
As per the circular of the Coal India Limited. He submits that the order is perverse and calls for interference. Issue notice to the sole respondent, for which requisites under speed post and ordinary process be filed by Friday. By Thursday, 7th, you file it. Pose this case on 8th of April, awaiting service report. Till 8th of April, the execution and implementation and execution of the impugned award is stayed.
The IA may be disposed of. No,
Acha, IA is disposed of. It is only till the next date. You can post it for final disposal. Post for final disposal. Let us see what happens. Once stay is granted, I don't want to keep it pending indefinitely.
Item 25 WPL 2353 of 2023.
Possible.
What is the matter?
Mr. Sanjay Prasad.
Mr. Sanjay Prasad is the matter? You just tell us what is the matter. You don't have the brief. Your senior does not give you the brief. No.
Second.
It's a denial of reference.
Reference has
Stay. Is it stay?
It is a stay. That's 1985 का death. और reference भी raise किए हैं after in 2015. Even the application has been filed after the lapse of.
He prays Passover.
Yes.
Let him come in the second half.
Yes.
You should tell your senior that if you will not give me the file, I will not act. Isn't it? How long have you been practicing?
7.
7 years.
Item 26 WPS 7188 of 2023.
Yes, petitioner.
Yes. I am reviewed by an except 3 and an except 4 laws. An except 3 has been issued by the respondent number 2, Secretary, Department of Education and Literacy. And on as per the instruction contained in except 3, Seniority list has been prepared in both the list. I have been excluded. So far myself is concerned, Lordship, I was appointed in the year 1994.
You're challenging the seniority list.
Seniority list we have, क्योंकि हमारा promotion
That's right.
होना
So
चाहिए.
those persons who are affected by your, suppose this writ petition is allowed, somebody has to be displaced.
नहीं, कोई डिस्प्लेस नहीं होगा इसमें. मेरा प्लेस नहीं है इसमें, मेरा प्लेस आ जाएगा. कोई डिस्प्लेसमेंट की बात नहीं है इसमें.
So you will become senior to somebody.
Of course, I am senior. I am senior. I have been
No,
excluded.
but this particular seniority list has become final. If you want to, you're not challenging.
I
this.
have a filed objection by an Excel file. Meanwhile, they have issued an order which I have challenged by amendment application, where I have to give the charge of by tomorrow Lordship. 5 दिन 2024 तक file charge दे देना है.
You see, if you still feel that no party is going to be affected by the relief which is prayed for, then I will record it, and if the respondents come up with a plea that the parties are going to be
Yes,
affected,
no party is going to be affected.
is nobody is going to be affected by his prayer?
No.
Lordship, one IEA has been filed, Lordship,
For?
for amendment.
Okay, उसमें
On the basis of this seniority list, Lordship, certain persons has been given promotion. So by this IEA,
promotion नहीं दिया गया. This is not a case of promotion.
in charge headmaster has been, so they have challenged those letters also by way of this IEA application, and they want to amend the main writ petition.
Just a moment. WPS number 7188 of 2023. The learned counsel for the petitioner submits that one interlocutory application being IA number 1882 of 2024 has been filed, challenging the subsequent order passed by the respondents, and the relief prayed through IA is a sequel to the main relief as prayed for in this writ petition. The learned counsel further submits that there is no need to make any private respondent in the present case, as the relief which is prayed for by the petitioner will not affect the seniority of one or the other person. Right?
Yes.
Subsequent to है development.
Yes.
Considering the fact that there is a subsequent development involved in the present case, which is a sequel to the relief prayed for in this writ petition, IA number 1882 of 2024 is hereby allowed. The counsel for the petitioner is directed to file an amended writ petition by 19th of March. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case, clearly indicating as to
there are
the
two players in his IE application also.
Yes.
One is regarding amendment, and second is regarding to stay the impugned office orders.
no, we are not going to stay anything.
So if Lordship will indicate that IE is allowed, then this.
IA is allowed to the extent. We are not going to stay anything. Stay का कोई prayer नहीं.
नहीं, extent prayer है.
Just a moment, right? IA is allowed. They will just incorporate, file an amended petition. We are not directing any stay. The learned counsel for the respondents are directed to seek instruction and file a counter affidavit in the present case. The counter affidavit should also indicate as to whether the right of one or the other person is going to be affected by the relief as prayed for by the present writ petitioner. Let the counter affidavit be filed by 2nd April.
इसी month में रखा जाएगा उसको.
Post on 16th April.
One thing I let us say one thing.
We'll see that later.
If Lordship is not staying the.
We will not stay.
No.
Because there is no private party. What state?
What will be problem, Lordship?
No, we will see that. Every problem will be
I
resolved.
will have to hand over the charge. I will have to work under a very much junior person who have been appointed in year 2019.
Item 27, WPS 7222 of 2023.
In a matter of promotion, you say that there is no private respondent.
This is not a matter of promotion, whether
Gradation list, promotion, these are all.
gradation list की बात नहीं है जो
Yes, petitioner.
I was praying for not today, Your Lordship. Mr. Indrajit Sinha has to argue this case. He is not in town. Your Lordship, we have challenged the case. The petitioner is a private company to provide ATM services and ATM to the banks, to the nationalized bank. Now, the Bank of India has entered into with an agreement with us to provide the ATM services. Now, we engaged a subcontractor to provide the security services. Now, the respondent number 6 has initiated proceeding under Minimum Wages Act.
And passed a final order.
Final order of rupees 1,92,000.
So?
That's
So you have come here, you don't have an appeal?
under the minimum.
There is no appeal.
Under the Payment of Wages Act, there is.
Then why don't you avail your remedies under appeal? What is it that has brought you here in writ petition?
Under the Minimum Wages Act, there is no provision.
There is no provision of appeal.
Under the Payment of Wages Act, there is.
The order has been passed under Minimum Wages Act.
Yes, Your Lordship.
What is your basic ground?
Basic ground is, Your Lordship, I have stated in my writ petition. The first ground which we have stated at paragraph 8, Your Lordship, that the petitioner company had not engaged any of the subcontractors in any scheduled employment, which can be termed as being under the authority and control of the state central government. The respondent number 4, that is the subcontractor which had been engaged for rendering security.
You were issued notice?
Yes, Your
Were
Lordship.
you issued notice?
Yes, I was issued notice.
You must have taken this stand before the respondents.
That stand has not been taken.
Where is your reply? You must have filed it along with the writ petition.
Annexure 4 is is the order, Your Lordship.
Where is your reply?
That reply is not on record, Your Lordship.
It is not covered under scheduled employment under Jharkhand Act. Minimum wages also has
Central
notifications.
government, here it is central government, Your Lordship. We are
This
stating
is
that the state government.
Central. It is there under the state.
Yes, Your Lordship, that is.
So this matter should have been taken up by the state government.
Yes,
You have made state also party.
the state has not been made a party, Your Lordship.
You are for union of India.
Yes.
Learned counsel for the parties are present. The learned counsel for the petitioner submits that the impugn order has been passed against the petitioner in spite of the fact that the nature of employment involved in the present case is not included in the schedule prescribed by the central government for the applicability of Minimum Wages Act 1948. The learned counsel for the responding number 1 and 2. Who is for 3?
3 Bank of India, Your Lordship.
Notice has to go 3.
I'll serve a copy to them.
You have served copies?
I will serve them, Your Lordship.
The learned counsel for the respondent number 1 and 2 is directed to seek instruction and file a counter affidavit in the present case. Issue notice to respondent number 3 to 5 under speed post as well as ordinary process for which requisites be filed by Friday. Preemptory. Post this case on 16th April under the heading for Under appropriate heading, the counter affidavits be filed by 9th of April. 9th of April. You file your counter affidavit by 9th of April.
My lords, may I seek kind indulgence of this honourable court for a minute, my lords, at the outset, may I express my sincere gratitude on behalf of the entire Delhi Bar Council and the Alumni Association of the Campus Law Centre for my lords' heroics in the constitutional law field is still an inspiration for all. And my lords are a fountain of justice. My lords,
immaterial.
my lords,
Does not make any difference.
my lords, my matter listed at item number 74, my lords, was put up for admission according to the last order of 6th of February 2024. My lords would grant me a hearing post-lunch. I'm ready with my
What is the matter?
My lords, it's with respect to the monetary benefits accruing out of the promotion that was due to the petitioner, but that was not given by the state. So, my lords, just 5 minutes, my lords, I have come.
Counter affidavit has been filed.
Beg your pardon?
Counter affidavit has been filed.
My lords had asked for the filing of the counter affidavit. They haven't filed it yet. I have not received it yet. My lords,
Serial number, get the serial number, get the file. We'll take up the matter, you get hold of the other side. Who is the counsel for the other side?
Mohammed Shahabuddin, my lords.
Mohammed Shahabuddin. You know him?
My lords, I'll get in touch.
Find it out from the state. Who is Mohammed Shahabuddin for the state? Any idea? You know them? You know him? He's for the state of Jharkhand.
Yes, my lords, he has.
I will inform.
He's a standing counsel.
Yes, yes.
You please inform him, ask him to be present.
My lords, may kindly grant me time, particular time, my lords. 2:30, my lords, I'll be here.
What time is your flight?
My lords, 2:30, I'm ready for the arguments because they had submitted.
What time is your flight?
My lords, it's in the evening, my lords. I'm here with my.
So it will be taken up at 2:15. We will sit. There are a few more matters fixed at 2:15. We will take up.
Obliged, my lords, obliged.
My lady, when matter was taken up at serial number 2, my lady has passed an order saying that it will depend upon the final outcome of the cases that have been. My lady, in that I want to submit only one thing, my lady, that the cases that have been mentioned in the conditions of the impugned order, my case falls within the four corners of those cases, my lady.
No, we will see that.
But I need to, because my lady, I will
No,
see
the
this
order
petition.
is also subject to final result
Because
of
he is
this
going to
meeting.
retire in this year itself, my lady.
You
I'll-
file your appropriate interlocutory application. Whatever.
Let it be posted on some date. I'll convince my lady that.
No,
that
it can't be. I've already passed an order. I've not done anything. I've just given a date. I've asked it to you. You say that those writ petitions have been disposed of. They are still pending.
They are of 2016 matters related to reservation, or they are
Not
they have-
2016 matters.
Yes,
They are
ma'am.
2022 matters.
2020. The lead
You were
case-
not there at that point of
So,
time.
my lady.
I have just posted it for a date. If you want any early hearing, if you file an interlocutory application, we will.
Order is conditional to the extent that until unless this order is disposed of, this case is disposed of, it won't be listed. Let it
No,
be
no,
listed.
no. It is not like that. I have already given a date also. I don't leave any case without a date.
It is of 2nd September. Early
No,
matters. Because he will retire.
time will pass like anything.
He will retire.
You file your
He's
interlocutory
59
application, we will
He's
consider.
59 years old, my lady.
You file your IE.